Hello, my name is Justice Michelle Quigley and I am the President of the Victorian Civil and Administrative Tribunal. I want to talk to you today a little bit about the work that VCAT does and the role we play in the civil justice system. VCAT is often described as a creature of statute. This means that VCAT has jurisdiction only where it's conferred on it by an enabling enactment. There are approximately 150 enabling enactments that confer jurisdiction on us and define our role and when that jurisdiction is invoked. VCAT is intended to be a forum freed from some of the complex rules that have built up around the mainstream court and court proceedings, and we are subject not to those more refined requirements of court procedure or rules of evidence, but we are bound by the rules of natural justice or procedural fairness. So when was VCAT created and why? Well, VCAT was created in 1998 by the passing of the Victorian Civil and Administrative Tribunal Act, which establishes our jurisdiction. We were the product of 15 boards or tribunals, and we joined together to make what has been referred to as a super tribunal. This was intended to simplify the number of administrative boards and tribunals to create a one-stop shop for administrative reviews in Victoria. VCAT differs from the courts in that we don't have any criminal jurisdiction, although we do have contempt powers. We only have civil and administrative jurisdiction. We are less formal and more accessible, although we do have some rules and processes. And prior to the pandemic, we sat in over 50 locations around Victoria, but not always in a courtroom. Tribunal members have specific expertise in their particular areas and hear cases across a wide range of matters, but they are not all lawyers. However, the decisions that we make are binding, like orders of a court. The tribunal's jurisdiction was intended to be broad. Under our rules, each of the enabling enactments is assigned to one of our VCAT line lists. Each list is established within one of the 5 divisions. Our divisions are the Administrative Division, the Planning and Environment Division, Civil Division, Human Rights and Residential Tenancies. And I'll say a little bit more about each of those shortly. What services does VCAT provide and to whom? Well, as I said, we are not a court and we are an alternative to court-like procedures in terms of dispute resolution. We resolve disputes in 2 general classes of matters: civil disputes, which generally arise from consumer law type enabling enactments, and administrative reviews, and they are generally reviews of government actions or semi-government actions. VCAT provides its services to the entire Victorian community across its 5 divisions and 9 lists and aims to be a low-cost, accessible part of the state's judicial system. So where do we sit in the judicial hierarchy? As I said, we're not a court, but we sit within the judicial hierarchy of the judicial system of this state. We are bound by decisions of the superior courts, essentially those decisions made by the Supreme Court or the Court of Appeal. VCAT's decisions can be reviewed by the Supreme Court under Section 148 of the VCAT Act. Under that provision, there is a statutory right to appeal to the Supreme Court on a question of law only, although a party can bring a judicial review proceeding under the Supreme Court General Civil Procedure Rules or under the Administrative Law Act. If the decision is made by the President, that's me, or a Vice President, one of our County Court judges, then the appeal is to the Court of Appeal. Otherwise, it's to the Trial Division. The right of appeal is not absolute. Leave to appeal needs to be granted, and it will only be granted where there is a real prospect of success. That's the threshold test for an appeal. It's important to note that VCAT is a specialist tribunal with members who have particular expertise in certain areas. And as I said, not all of our members are legally trained. We have land valuers, town planners, accountants, architects, engineers as part of the cohort who are our members allocated to the specialist list. Generally, those sorts of people are allocated to the planning and environment list, but we also have a number of medical practitioners and other specialists who are assigned to our review and regulation list for various disciplinary and other matters that the enabling enactments require us to have those specialists appear in or sit in. So what are the sorts of disputes that we hear? The source of the power sits within the enabling enactments and the VCAT Act itself. And when I refer to enabling enactments, that might be any piece of legislation of those 150 or so, like the Planning and Environment Act, the Land Valuation and Compensation Act, the Residential Tenancies Act, the Guardianship Administration Act, and if you go to our annual report, you'll see the long list of pieces of legislation that are the enabling enactments that give us the jurisdiction to hear the specific reviews or appeals that the legislation provides. Each year, we hear and determine approximately 85,000 matters. Of these, about 55,000 of them are residential tenancies matters. Given the breadth of the divisions and the lists within the tribunal, the sheer number of enabling enactments, the types of matters that come before us are very diverse. In the review and regulation list that sits within the administrative division, it has over 80 enabling enactments. Generally, they deal with disciplinary matters against health practitioners, review proceedings such as freedom of information applications, state duty or taxation appeals, reviews of working with children, victims of crime assistance tribunal reviews, child welfare case plan decisions, transport accident commission matters, and in those, at least one of the parties is represented. Often in matters before the tribunal, people come along and represent themselves. In the legal practice list, again in the administrative division, these are matters that arise out of the legal profession uniform law, and they deal with costs dispute between a client and their lawyer, up to a cap of $30,000, and disciplinary actions taken by the Legal Services Commissioner or the Victorian Legal Services Board against practitioners. In the human rights list, matters under the Equal Opportunity Act, which are legally complex and often resemble a claim for damages and may involve various alternative dispute resolution. I'll come back to that. And they're often interlocutory injunctions and the like. Other matters in the human rights list include applications under the Health Records Act, Privacy and Data Protection Act, Disability Act, Voluntary Assisted Dying Act, and the Mental Health Act. In the building and property list that sits within the civil division, matters under the Domestic Building Contracts Act, which can range from simple mum and dad type renovation disputes with their builders, all the way up to large multi-party, multi-million-dollar litigation to do with high-rise developments, particularly those more recently in relation to flammable cladding and the like. And in those, there can be more than 20 parties, all of the different consultants and the like involved. We also have jurisdiction under the Water Act, and these are claims for what are said to be unreasonable flow of water, like a building, like a little bit like a building case. And also we have jurisdiction under the Retail Leases Act, which can involve small businesses operating out of a single location up to disputes in relation to large retail shopping centres. In our owners corporation list, which sits in the civil division as well, disputes between owners corporations and lot owners under the Owners Corporation Act, and claims for unpaid body corporate fees and disputes about repair and maintenance costs or common property, or applications or amendments of plans under the Subdivision Act sit within that list. In the Planning and Environment Division, we deal with planning and environment disputes under the Planning and Environment Act, the Environment Protection Act, and Land Valuation and Compensation Act matters as well. So that covers the full range of planning disputes, environment disputes, prosecutions and the like, although not those that go to the magistrate, others go to the Magistrates Court, and rating appeals and compulsory acquisition claims. That's a very busy list with people who sit in that list involve our various specialists and lawyers as well. In those, we often have represented parties because of the value of the matter that's involved, but very commonly lots of self-represented litigants. In civil claims, these are the claims brought under the Australian Consumer and Fair Trading Act, and they may include small claims of less than $15,000 through to complex claims of more than $100,000. These disputes are about supply of goods and services. There are no financial limit on what the tribunal can hear in these consumer disputes, and they can be from relatively small but emotional disputes like the dry cleaning of a wedding dress through to a tradesman claiming an unpaid debt for work that he has done, through to large complex commercial matters including the sale of businesses, negligence claims against service providers, disputes about manufacture of expensive items such as a caravan, and we have quite a large jurisdiction in motor car defects. Disputes under insurance policies between franchisees and franchisors, and also cases that relate to misleading and deceptive conduct or false representation in consumer claims, consumer matters. These are many and varied and can involve quite complex factual matters through to quite simple debt recovery matters. In residential tenancies, there's a very high volume list that handles disputes between landlords and tenants, rooming house owners and rooming house residents, the Director of Housing and public tenants, other providers of community housing and tenants, or caravan park owners and their residents. And in the guardianship list, this is also a very, very busy area of our tribunal. Protective orders under the Guardianship and Administration Act and other similar legislation. The most common orders appoint a substitute decision maker for adults who are unable to make decisions for themselves in relation to personal matters, medical treatment decisions, financial matters, powers of attorney and the like. The nature of the VCAT's jurisdiction means that it's really important when you're looking to see whether we have jurisdiction and the extent of it, to look at the enabling enactment under which the proceeding is brought. This is particularly so because there are some special rules apply under those enabling enactments which override the general operations of the VCAT Act. Where there is an inconsistency, the Enabling Act prevails. Put simply, the enabling enactment defines the function of the tribunal on review and may impose substantive or procedural requirements that aren't otherwise found in the VCAT Act or may be inconsistent with the VCAT Act. And that's not to say that the VCAT Act doesn't have a very important part to play. To the extent that the enabling enactment is silent on the matter, the VCAT Act prevails and furnishes the tribunal with the powers necessary to conduct a proceeding. Many of these powers are procedural in nature, for example, the power to make directions, to issue witness summonses, and refer matters to alternative dispute resolution. VCAT makes decisions and resolves disputes. It doesn't provide legal advice. That said, we have many self-represented litigants who need assistance in navigating the process. There are limits set in the VCAT legislation as to when a party can be legally represented or represented by another advocate. Under Section 3 of the VCAT Act, a proceeding is defined to include compulsory conferences and mediations, as well as the hearing itself. Section 62 of the VCAT Act says that a professional advocate may appear for a party where their client is listed in the specific list, which includes children or councils, government entities, where another party has an entitlement or is already being represented by a professional advocate, where the parties agree, or where the tribunal grants leave for that to occur. In determining whether or not to grant leave for a party to be represented by a professional advocate, consideration is always given to the stakes and the complexity of the matter. In some lists, it will be particularly likely that the party will be represented. For example, in the planning list, where a council is always a party, then it automatically follows. In such cases, leave may not be necessary, and in other cases, of course, permission may be required, and others, it may not be an issue at all. So what is the structure of VCAT? The tribunal structure is determined by the VCAT Act, and the structure consists at the top, the president, myself, vice presidents, deputy presidents, senior members, ordinary members, not that they are ordinary, and the principal registrar and deputy registrars. The president is a Supreme Court judge appointed for a term of 5 years and responsible for the directing the business of the tribunal, with help from the vice presidents, as well as presiding over some of our more high-profile matters. Vice presidents are county court judges, also appointed for 5 years, and at the moment we have up to 10 vice presidents available to us. Deputy presidents are members with a leadership role who commonly have responsibility for managing a division or list, and senior and ordinary members make up the balance of our membership. They're all appointed for a term of 7 years. The principal registrar is also provided for by the VCAT Act, and the principal registrar needs to give assistance to participants in a proceeding, although not extending to provision of legal advice. This is part of our Access to Justice Charter. We have a CEO who is responsible for leading our executive team and for running the corporate part of the organisation. The principles of access, fairness and equality underpin the VCAT legislation and our operations. When we were established, it was government's intention that we be flexible and cost-effective in our practices, and we were to promote relatively informal, inexpensive and efficient dispute resolution. So consistent with that intention, the tribunal under its legislation may regulate its own procedure, is not constrained by the rules of evidence or procedure applicable to the superior courts, except to the extent that we decide to adopt them. We have the power to inform ourselves as we see fit, and we must conduct proceedings with as little formality and technicality as the speed as proper resolution of the matters before it permit. We are bound by the rules of natural justice and must act fairly in accordance with the substantial merits of the case. These fair hearing obligations guide VCAT in the regulation of its procedure. Crucially, they don't demand a standard of perfection, but must account for fairness to all parties. There is a considerable amount of authority on those obligations, and you can look at our website to find some further information directly about that. There is a further schedule to the VCAT Act which also sets out some specific practices and procedures that apply to specific lists. So again, looking at our website is a great source of information about the work of VCAT and the respective lists. Some of the practices and procedure vary quite considerably between lists. So in the planning environment list, the review and regulation list, the building and property list, they are very much case managed matters because they are often quite complicated. Whereas the residential tenancies and civil claims lists are a little bit more straightforward. A number of the lists have more complex statements of claim or pleadings that set out the ambit of the dispute. Others, such as civil claims, proceed on the basis of summary proofs of documents, position papers or statements of contention. Expert witnesses are common in some of the lists, like planning or building and review and regulation. The Tribunal's practice notes provide further guidance on the procedural requirements applicable to each list and at the Tribunal level. The website is a good place to find any current changes to our practices and processes. I want to say something a little bit about technology. Prior to the COVID pandemic, we were very much paper-based and face-to-face in terms of our dispute resolution. We have moved to hearing all matters by alternative means, by telephone, by Zoom, some on the papers. The kind of technology varies across the lists, with residential tenancies and civil claims often by telephone, and the others, the more complex with lots of parties, by Zoom. In all lists, we conduct alternative dispute resolution, mediations, compulsory conferences, which are generally held by video conference, although some by telephone. In the residential tenancies list, all fixtures are pretty much dealt with by telephone. Where technology is to be used, VCAT provides the details of the platform to be used ahead of time to the parties. That information will include instructions how to access the platform, and the matters which are heard by video conference, we have a virtual bench clerk, a real person, but online to assist us and the parties to connect before the commencement of the hearing. In civil disputes generally, we do use alternative dispute resolution to a great extent. This is a more informal means of dispute resolution rather than a formal hearing, although hearings at VCAT tend to be a little less formal than you might find in the mainstream courts. We have powers to require parties to attend ADR, and it will depend on the complexity of the matter and where it is in the process as to what form that might take. We use mediation and compulsory conferences as the two key ways. Mediation is a process where an independent and impartial person attempts to assist the parties to come to an agreed resolution. Mediations are generally conducted by external engaged mediators who are not VCAT members. We use the Dispute Resolution Centre of Victoria members generally to do that. They don't intervene like a member would. In civil claims, there's a fast-track mediation process, which is a process by the mediator attempts to mediate an outcome, but if the matter isn't resolved, it proceeds immediately to a formal hearing on the same day by a member. Currently, in the pandemic, we're not using that process, but we will go back to that when things settle down a bit. Compulsory conferences, by contrast, is a mixture of a mediation and a directions hearing. Those conferences are conducted by members with a view to clarifying issues in dispute, promoting settlement, identifying questions of fact and law, and making binding directions for the future conduct of the proceeding. Compulsory conferences are similar to mediations in that they are conducted in closed tribunal rooms. Evidence of what is said and done in the course of a compulsory conference or a mediation is inadmissible in a hearing except in very limited circumstances. So they are confidential to try and encourage the parties to come to a sensible resolution. Where a member has heard a compulsory conference, a party may object to that same member hearing the matter if it proceeded to hearing, and generally we wouldn't list that person unless there was some good reason to do so. A member will often act like a mediator, attempting to help the parties reach a settlement, including using some sort of shuttle mediation techniques, although members in compulsory conference may be much more interventionist than a mediator does. If settlement is reached in a compulsory conference, the member can make orders and directions to resolve the matter completely. In a mediation, the parties sign up to a consent agreement. Either way, a binding decision that parties have come to can be put in place. We also deal with some matters, what we call on the papers, and this has been particularly useful to us over the pandemic when we have been limited in the ability to have any face-to-face hearings. Where parties agree to the matter being settled on the papers or on the documents, we can utilise that power, but we do have the power to decide to do that in any event if we think that it's in the interest of justice to do so. So that brings me to the end of my brief outline of all of the extensive work that the Tribunal does. I hope that's provided you some insight into the work and the jurisdiction of the Tribunal, and I wish you all the very best with your studies. Thank you.